Hello, I am Abigail Reynolds, an admitted attorney in South Africa. I want to talk to you today on behalf of Carrick Consult about why it's important to have a valid will in place. A will obviously allows you to specify who you want to benefit from your estate and in what proportion. If you don't have a will, you have no control over this, and some people you care a lot for could get less than you wanted, and some people could benefit that you didn't want to leave anything to at all. More importantly, it helps clarify your final wishes and it avoids family quarrels. It's useful because it allows you to nominate an executor of your choice, and that person will be responsible for the administration of your final estate and giving effect to those final wishes. If you have a will in place, it makes a clear will in place, it makes the administration much easier and hopefully quicker, because winding up an estate can take a year or two, which can be difficult on the families, so the quicker it can be done, the better. It's even more essential that you have a valid will in place if you have dependents, because in your will you can provide instruction for how you want your assets to be used to care for them, such as providing housing for them, education, caring for their medical needs, and other things. And if you have minor children or if you plan to have children, we highly recommend you have a valid will in place. The most important reason being to set up in the will a testamentary trust for the minor children, and that's anyone before they reach the age of 18, so that the trustees of the trust can manage the assets that they inherit on their behalf, and they only get access to the money when they turn 18, or even at an older age if you prefer to choose, such as 21, 25 or 30, if you don't want them to access the funds so young. And the second good thing about this for minor children is that you can appoint a guardian to look after them if you and the other parent die simultaneously. The will also allows you to make a donation to a charity or another organization of your choice, and this can be a powerful thing because you can leave a legacy in your will that reflects the values that you held dear while you were still alive. It can also record other wishes, such as whether you want to donate your organs, whether you want to be buried or cremated, and any other specific wishes around that, and also who you would like to care for your pets, and perhaps also leaving them with an inheritance so that they have the finance to care for the pets properly. Your will can also deal with all of your offshore assets, and we can advise whether or not you do that within your South African will, or whether you have separate wills for each country outside of South Africa in which you hold assets. But you can at least deal with all of those and again nominate the beneficiaries for same. And then on a last point, to make it valid, there are certain requirements. It does need to be signed in front of 2 witnesses. Those witnesses cannot be beneficiaries of the will, and there needs not be a large gap between the last clause of the will and the signatures. So there are some of those requirements which we can also assist you with and make sure that your will does in fact end up being valid. Thanks so much. Bye.